Hello, everyone, and welcome back. Before we continue, I will go and remind you that I am not a lawyer. I do not have any certification to practice law in Vietnam. I'm just simply a foreigner from the United States who knows the labor code. This is my second attempt to make this video, as the first attempt resulted in it getting rejected because of the software I use is free and it only allows me to make 5 videos a day. So I didn't know I was at my 5 video a day limit until I actually hit it. So we're going to go ahead and move on. This video is about the gender equality laws that are inside of the Labor Code of Vietnam. These are Articles 135 to Articles 142 and literally tell you everything you need to know about gender equality. Now, here's the thing. As far as the LGBT community goes, yes, I really wish that you pay attention to this. Yes, Vietnam is making great strides in recognizing the LGBT community. They are even amending the family law, from what I understand, to include LGBT people. Now, I am not sure exactly what that entails because I have not read the amendments myself, but I sincerely hope that it allows everyone to go ahead and raise a family, get married, adopt, stuff like that. So, the reason why I mention this specifically is because of the T part, the transgender community. Female to male transgender, this may not apply to you because you identify as male. Therefore, you are counted as male under the law now because transgender people are recognized under Vietnam's law. Believe it or not, they really are. So, transgender people are recognized under Vietnamese law, and you can go and get a certificate that says that you are now a man or that you are now a woman, and then, well, that's that. But anywho, moving on. So, what I'm talking about are male to female transgender. If you were born a man but you identify as a woman and you have had, I don't know, pre-op, post-op, doesn't matter. If you're male to female transgender, you identify as female, you'll be counted as such. Therefore, this section will apply to you. So, we will go ahead and move on. Now, again, just like I always say, with me, I don't simply go from point A to point B. It's point A to letter Q to square root of pi to, the color red, and then, some tree branch I saw the other day, all the way back to letter B. So, yeah, that's the reason why we're doing all this stuff like in that kind of way. Now, the other reason why I'm teaching you these laws in order that I'm doing it is because you need to know these laws before you're hired. Before you're hired, you need to know these laws. Therefore, you'll know whether or not your employer will be treating you properly. And here in Vietnam, there's a lot of employers that don't know how to treat their employees right. So, we will go ahead and move on. Like I said, I'm going to try and explain this again, so hopefully I remember all the words. All right, we're going to go ahead and get started. Now, again, I'm using cheap software, so I can't switch the screens or anything like that like you can do on Google Meet. I wish I had that kind of Google software, but just for this, so I could record stuff. Anywho, we are here, and these are the labor codes, one in English, one in Vietnamese. Now, as you can see, I always try and keep them both together at the same time so that you can see that I am talking about what I'm talking about, and anybody who speaks Vietnamese can go ahead and see that, yes, he is talking about what he is talking about. So, whether you understand English, whether you understand Vietnamese, these videos are for you. So, moving on. Chapter 10. Provisions applicable to female employees and assurance of gender equality. Article 135. Moving on up. There we go. All right. Article 135, Clause 1. Equality between male and female employees shall be ensured. Necessary measures for ensuring gender equality and prevention of sexual harassment in the workplace shall be implemented. This means that it is required. State policy. This means it is a policy of Vietnam that there will be equality between male and female employees. It's not optional. The government of Vietnam requires it. And there will be necessary measures to ensure this and to prevent sexual harassment in the workplace. Now, to define sexual harassment, that is any unwanted action towards another person. Now, it may not be sexual in nature, but if it's considered sexual harassment, it's considered sexual harassment. Now, there is such thing as sexual harassment against men. Now, there's a large group of people that believe that only sexual harassment can happen to women, not men. That's simply not true. See, with me, I'm a married guy. Now, because I'm a foreigner, a lot of people will see that as one thing in of itself. So, back when I was teaching English, I would have a lot of female TAs that would be so happy to see me the first day and everything like that. But then after I go and introduce myself to the class and I tell them that I'm very happily married, I kind of give the hint to the female TA that I'm married and I don't want anything on the side. So the next day they turn up, they're sullen, they don't want to do anything, they're lazy. Yeah, I want to say it, they're lazy. They don't want to do their work, they don't want to translate, they want to sit at the desk and play on their cell phone all day while I'm struggling to try and teach a class full of disobedient students. Yeah. So that is a form of sexual harassment because if she is not happy and cheerful every single day, she's only happy and cheerful for that first day, but then after I make it clear that I'm married and then the next day she's completely not nice, yeah, that's sexual harassment. Because that's harassment against people who are married. So moving on. Clause 2. Moving on up. Employers are encouraged to enable both male and female employees to work regularly and to widely apply the systems of flexible working hours, part-time work, or outwork. Basically, employers are required to encourage their employees to work. That's what it says. And if you don't make enough money, you're encouraged to go ahead and seek more work. That's what that means. Clause 3. Necessary measures shall be implemented to create employment opportunities, improve working conditions, develop occupational skills, provide health care, and strengthen the material and spiritual welfare of female employees in order to assist them in developing effectively their vocational capacities and harmoniously combine their working lives with their family lives. Now, what this means is that with the state will go ahead and create necessary measures to create employment opportunities for women, improve working conditions for women, develop occupational skills for women, provide health care for women, and strengthen the material and spiritual welfare of female employees in order to assist them in developing effectively their vocational capacities and harmoniously combine their working lives with their family lives. Now, that last part, see, the material and spiritual welfare, material means to go ahead and develop the woman through all of these measures, such as employment opportunities, improving working conditions, all the stuff that it mentions to improve this woman so that her material welfare is improved. Therefore, her spiritual welfare is improved as well, because if you don't look at it as religious, just spiritual in general, if she has high spirits, this means that she is very happy. So if she is treated well, given these opportunities, she exceeds at these opportunities, she will strengthen her material and spiritual welfare through help of the state. That's what this means. And also, it means that to do that effectively, through their vocational capacity, this means that to do this, they will go ahead and assist you in developing what you're supposed to do with your life. Like if you want to be a teacher, they can assist you in becoming a teacher. If you want to be, a big boss, they can assist you with that. That's what that's there for. Now, here's the thing. Moving on. So we've already talked about Clause 3. Now, working lives with their family lives. So what the government of Vietnam wants to do, in my opinion, is to make sure that the female employee is treated with respect and dignity, as well as having opportunities to improve her life so that she can improve her conditions and to go ahead and make herself happier in the process. Now, to combine working life with family life, you have to have harmony and synergy between the two, because if you don't, it's going to go ahead and cause problems. That's what that means. To harmoniously combine your working life with your family life, there has to be, some sort of synergy with that. Now, the thing is what they mean by that, to harmoniously combine your working life with their family life. If she has all of these opportunities and she takes them and she exceeds at them, therefore her vocational capacity will be greater. She gets a raise. It helps her material and spiritual welfare, which then combines harmoniously with her family life because it makes her family life a lot better. Now, this can also mean if a woman lives with her family or if she has a family of her own. I think so, anyways, because some women choose to not have a family, and that's their choice. In my opinion, I am pro-choice because I believe not only women, but anybody has a right to do with their body as they see fit after they reach the age of decision. Now, the age of decision in the United States is 18, but yet you're not allowed to drink or smoke until you're 21, or own a handgun for that matter. Now, also, well, technically you can have a rifle at 18, but that's beside the point. In Japan, it's actually 20 for the age of decision. That's when in Japan someone turns an adult is when they turn 20. Now, you do see signs that say 18 this, 18 that, yeah, but the actual, they turn an adult when they turn 20. So each rule of each country is different, but yeah. So, anywho, moving on. So, number 4. You ever wonder why you go ahead and walk around here in Vietnam and you go ahead and see a lot of female employees that work for one particular company? This is why. Tax reductions shall be granted to employers who employ a large number of female employees in accordance with the tax laws. Now, I'm not quite sure what this deals with. I have seen the tax laws, but I haven't seen anything like this. I'm gonna have to go through that again sometime. But it specifically says that employers will be granted a tax reduction when they employ a large number of female employees. So if you have, like, say, 2 male employees and you have 50 female employees, that's why. It's because of this. They get a huge tax break. Now, in my opinion, true equality should mean that the best person for the job, not hire women because you get a tax break. Just my opinion. Because of the fact that a lot of companies here in Vietnam, they will not go ahead and care so much about the quality. They only want people to go ahead and do a job. Now, I can't speak for all companies, but, most companies are like that. So, when you go ahead and see this, and you see, like I said, large numbers of female employees, this is why. Now, to be very clear, my previous statements about Clause 4 are not sexist in any way, shape, or form, because of the fact that here in Vietnam, I have observed this with my own eyes about very large numbers of female employees working for one person. There's hardly any men at all. It's almost always female. So it's not intended to be sexist in any way, shape, or form. I've actually seen this. And you know what I know now, that the employers are getting a huge tax break because of that. But again, like I said, I'm a fan of the best person for the job. Doesn't matter about their gender or how old or young they are. If they're the best person for the job, they get that job. So moving on. Clause 5, the state shall develop plans and measures to open daycare facilities and kindergartens in areas where a large number of female employees are employed. Develop various forms of training to enable female employees to acquire additional occupational skills that are suitable to their physical and physiological characteristics and their motherhood roles. So what this means is simple. Vietnam will develop plans and measures to open daycare facilities and kindergartens in areas where a large number of female employees are employed. Right here, this is talking about industrial workers, like large-scale industrial workers. See, Ho Chi Minh City, we do have a lot of factories and industrial zones, but a lot of areas in Binh Duong province are known as industrial hubs. My brother-in-law owns a wood factory in Binh Duong, so yeah. Now, essentially, what they're talking about is they need to build daycare facilities where large numbers of female employees are located at. So that's what I was talking about. The state needs to do that in areas where a large number of female employees are located. Develop various forms of training to enable female employees to acquire additional occupational skills that are suitable to their physical and physiological characteristics. So what this means is to train the female employee to develop various forms of skills to acquire more skills that are suitable for your physical body characteristics and motherhood roles. Now, again, if you choose not to be a mom, that's your choice, and I support that. So, moving on. Now, again, I'm going to go ahead and say this because I know I'm not done, but I'm going to go ahead and say this anyways, and I'm probably going to say this a lot. Yes, I know I'm not a woman. I am a cisgendered man. And I know I'm not qualified to talk about female matters because of this, but I do know a thing or two, and these series of videos are educational in nature, even though they're marked as entertainment. So, let's just go ahead and get through this together, all right? So, Clause 6, the government shall elaborate this article. Moving on. Responsibilities of the employer. Right there. Now, these ones are going to be the big ones. I think these are going to be the big ones. Responsibilities of the employer. Article 136. Ensure gender equality and implementation of measures to promote gender equality in recruitment, job assignment, training, working hours, and rest periods, salaries, and other policies. That right there. Salaries and other policies. Now, why is this important, you might ask? Because of the fact that the employer is required to ensure gender equality in everything they do. They're required to implement gender equality in everything they do, from recruitment, job assignment, training, working hours, rest periods, everything, salaries, other policies, everything must be equal. So Article 136, Clause 1, remember this, ladies. Local ladies, foreign ladies, remember this. Article 136, Clause 1 states that your employer must pay you the exact same as a man for the exact same work performed. Article 136, Clause 1, ladies. Please remember that. Clause 2, which again, this is the mirror side. 136, Clause 2. Consult with female employees or their representatives when taking decisions which affect their rights and interests. So essentially, the employer is required by law to consult with the female employees or representative of female employees when making decisions that affect their rights and interests. Now, what these might be, I don't know. But if it has to do with this, which I'm pretty sure it does, that the employer must talk with the employee about this. We'll go ahead and get to that later on. So, provide appropriate bathrooms and toilets at the workplace for female employees. What this means is a toilet. Basically, a bathroom with a toilet in it. That's it. Now, for most factories, from what I understand, they're basically unisex. You know, you have 2 toilets, 1 marked man, 1 marked woman. That's it. You know, to go ahead and simplify things, maybe 2 toilets marked men, 2 toilets marked women, but they're both the same thing, just a toilet and a sink, and that's it. But it does say that they are required to provide bathrooms for female employees. So yeah, right there. Number 4, right up here. Assist in building daycare facilities and kindergartens, or cover a part of the child care expenses incurred by employees. Right here. So if you are a female employee and you have a kid that requires daycare services, your employer is required to cover a part of the child care expenses incurred by employees. Now, this may apply to male employees too, but I'm not really too sure. So you would have to consult with the labor lawyer about that. Article 137, maternity protection. Right there, right there. All right. Now, moving on. Maternity protection. An employer must not require a female employee to work at night, work overtime, or go on long-distance working trip in the following circumstances. The employee reaches her 7th month of pregnancy or her 6th month of pregnancy when working in upland, remote, border, and island areas, which means if you are any one of these, you your employer is not required to make you, you must not require a female employee to do this stuff if you're an employer. So if a woman reaches her 7th month of pregnancy or 6th month if she's working in remote areas, then she can't work at night, work overtime, or go on long distance trips. B, the employee is raising a child under 12 months of age unless otherwise agreed by her. So the employer cannot require the female employee to do this if she's raising a child under 12 months of age, unless otherwise agreed on. Clause 2. Whenever an employer is informed of the pregnancy of a female employee who is doing a laborious, toxic, or dangerous work, a highly laborious, toxic, or dangerous work, or any work that might negatively affect her maternity, the employer shall assign her to a less laborious or safer work or reduce the working hours by 1 hour per day without reducing her salary, rights, or benefits until her child reaches 12 months of age. Now, why is this important? This law, Clause 2, is mostly for industrial workers. But what this means is that if a female employee is pregnant and she's doing something toxic and the employer cannot go ahead and assign her to a less laborious or safer work, he can't do it. He has to reduce the working hours by 1 hour per day. So instead of 8, she only has to work 7, but still receive the same pay for 8 hours without reducing her salary. So she still gets paid for 8, even though she only worked 7 hours, without reducing her salary, rights, or benefits until her child reaches 12 months of age. Moving on. So we got Clause 3. The employer must not dismiss an employee or unilaterally terminate the employment contract with an employee due to marriage, pregnancy, maternity leave, or nursing a child under 12 months of age, except for cases where the employer that is a natural person dies or is declared incapacitated, missing, or dead by the court, or the employer that is not a natural person ceases its business operation declared by a provincial business registration authority that it does not have a legal representative or a person authorized to perform the legal representative's rights and obligations. Upon expiration of the employment contract with female employee who is pregnant or nursing a child under 12 months of age, conclusion of a new employment contract shall be given priority. Now, what this means is very simple. The employer under the gender equality laws, please make sure you write this down. Article 137, Clause 3, maternity protection. Article 137, Clause 3. Again, please write this down. Article 137, Clause 3. Now, why this is important is very simple. Read very carefully. Must not dismiss an employee. This means that your employer is not allowed to fire you. Okay, let's just do this. The employer must not dismiss the employee. Means the employer cannot fire you or unilaterally terminate the contract. Yeah, same thing. Means cannot fire you. Due to marriage, if you get married, the employer can't fire you. If you get pregnant, the employer cannot fire you. If you take maternity leave, which will be discussed later on, the employer cannot fire you. If you are nursing or taking care of a child under 12 months of age, again, the employer cannot fire you, except for that case where they mentioned. Now, the other thing, upon expiration of the employment contract with said female employee who is pregnant or nursing a child under 12 months of age, conclusion of a new employment contract shall be given priority, which means the employer must give her a new employment contract if her previous one expires and she is either pregnant or nursing a child under 12 months of age. He must give her a new job. Right there. So if your boss does not give you a new job after your contract expires and you are pregnant or nursing a child under 12 months of age, that's a lawsuit. Now, Clause 4. Again, I'm not a woman, I know, but I'm going to talk about it anyways because it's there. Let's get through this. So, and again, please bear in mind, everything I mention is in educational context. I'm not trying to be, whatever. This is all educational context. Let's move on. So, Clause 4. During her menstruation period, a female employee shall be entitled to a 30-minute break in every working day. A female employee nursing a child under 12 months of age shall be entitled to 60-minute breaks in every working day with full salary as stipulated in the employment contract. Why is this important? Because of the fact that, and again, speaking from educational context, so please bear that in mind. when women go through their monthly period, they experience a lot of cramps and, being tired and stuff like that. And that is one of the reasons why this 30-minute break period has been assigned, but you only get it once. It says a 30-minute period. This is once in every working day. And if a woman is breastfeeding, lactating, then that means she can go ahead and take 1 hour, up to 1 hour. Well, it says shall be entitled to a 60-minute break. So, maybe about an hour once a day to go ahead and do what you need to do. So, yeah, to go ahead and do what you need to do, then, yeah, you get an hour to do that. And it's right there with full salary. So that means they are not allowed to take your salary away if you need to take 30 minutes because you're menstruating or you are dispensing breast milk into a bottle because you are taking care of a child under 12 months of age and you are entitled to that 60-minute break. So if they don't pay you, that's a lawsuit. So yeah. And again, ladies, I know I'm not qualified to speak about this, but it's there and I want to talk about it, and it's in an educational context, so I hope I'm doing a good job. Let's move on. Article 138. This is another big one for female employees. The right of pregnant female employees to unilaterally terminate or suspend their employment contracts. And again, the Vietnamese version's on the other side. Clause 1. Where a female employee is pregnant and obtains a confirmation from a competent health facility which states that if she continues to work it may adversely affect her pregnancy, she shall have the right to unilaterally terminate or suspend the employment contract. In case of unilateral termination or suspension of the employment contract, a notification enclosed with the aforementioned confirmation from the health facility shall be submitted to the employer. Now, from what I know, TUYÂ Hospital here in Ho Chi Minh City is the premier place to go. It's the best hospital. Now, I didn't quite have the best experience myself when my daughter was born, but that's another story for another time. Yep, that's the story for another time. All right, so moving on. Yeah, TUYÂ Hospital really is the best facility that even when the foreigner hospitals have problems, they have to send their patients to TUYÅ Hospital. So go there, and if TUYÅ Hospital says that your job, whatever it is, if it's going to adversely affect your pregnancy, then you can get that certification sent to your employer from TUYÅ Hospital that states that, so that they know, so you can either suspend or terminate your employment. If it's that bad, you should terminate your employment. If it's not that bad, I would recommend suspension instead, but that's just me. So that says right there. Right here, right here. All right? Right here, right here. Now, clause 2. In case of suspension of the employment contract, the suspension period shall be agreed by the employer and the employee and must not be shorter than the period specified by the health facility. If the rest period is not specified by the health facility, both parties shall negotiate the suspension period. So essentially, if TUYÅ Hospital says that the suspension period must be, say, 6 months, all right? The suspension period between the employer and the employee cannot be less than 6 months. However, if there is no minimum amount, if TUYÅ Hospital doesn't give an amount, then the employer and the employee can go ahead and come to a mutual agreement about how long the employee should be suspended for due to pregnancy problems. Now, this is, to be very clear, this is a voluntary suspension. This is not the employer suspending you because you're pregnant. Remember, we already covered that. That's illegal. This is voluntary on your end in case there is something wrong. Moving on. Article 139, maternity leave. This is what we're talking about right here. Again, maternity leave, maternity leave. Clause 1. A female employee is entitled to 6 months of prenatal and postnatal leave. The prenatal leave period shall not exceed 2 months. So this means that you can take up to 6 months total for pregnancy leave. You can take up to 2 months beforehand, but that means you only have 4 months afterwards. If you take 1 month beforehand, you have 5 months afterwards. So you should think about that.